Technical difficulties. Okay, I want to welcome everybody to Meltzer Hellrung September webinar here on the H-1B rule as well as the new H-1B fee. And the original version of the webinar was to cover travel through the holiday months, but certainly as things have changed in the last week or two or week or so, we are covering these brand new topics as well today in today's webinar. A little bit about our firm here. Meltzer Hellrung, we've combined an innovative service model, proprietary technology, and a creative immigration team to solve immigration solutions and provide immigration solutions for our clients. A cross-section of our book of business looks like about 200 to 300 active clients. And those clients are in the Global 200, Fortune 500, venture-backed unicorns, small, medium-sized businesses in manufacturing, SaaS, robotics, AI, tons of spaces. In 2023, we were recognized by Crane Magazine as one of the 100 best places to work in Chicago, which we're super proud of. And most recently, in 2025, we were recognized by Chambers Spotlight as a top firm handling immigration work in the state of Illinois. A little bit about our service model as a firm before we get into the meat of today's presentation. We really emphasize responsiveness in our business model to serve clients, which means that we track all email timing in the firm, and on average we respond in about 4.5 hours to emails during a business day, which is Central Time 8 a.m. to 6 p.m. We are really efficient with processing our casework. We turn around those transfer cases for your organization to get those new employees onboarded in 10 business days from initiation to filing with USCIS. We are very feedback focused in our service model to clients, and we collect feedback from for each case or matter that we process for a client on a scale of 1 to 10. We throw that into an NPS or Net Promoter Score structure. For anybody who's unfamiliar with the structure, anything over 70 is generally considered to be best in class. To date this year, I believe our score is 90 or 91. It was 90 or 91 in 2024 as well. And then outside of just processing cases and getting visas approved and green cards approved for your clients, both in the US and abroad, we really focus on managing your program as a firm. This means that you get an assigned and dedicated account team that is your point of contact, multiple points of contact, and within that account team at any given time. And we establish regular touch points with our clients to manage your programs in addition to budgeting, projections on when extensions need to be renewed, working on immigration policy for our clients. And we also offer most recently, and have for a long time now, but to emphasize it, compliance work with regard to I-9s and audits. A bit about our presenters today. You've heard me speaking for the last few minutes. My name is Matthew Hellrung. I'm co-founder and managing partner of the firm. I specialize in scaling U.S. immigration programs for our high-growth clients. This is typically done with immigration policy creation, stakeholder training, procedure, SOP development. And I've represented clients in a variety of industries and sizes, from information technology, engineering, education, manufacturing, entertainment, from two-person startups up to your global 200 clients. With me today, is our senior counsel. Just a second. Michael Turansick. Mike, do you want to introduce yourself?
Sure, yes. Good morning, good afternoon, everyone. Thank you again for making time out of your busy schedules to be here with us today. My name is Michael Turansick. I'm senior counsel at Meltzer Hellrung. I've been practicing primarily employment-based immigration law for over 30 years now, at big firms, at medium-sized firms, and at smaller firms, and had several years of experience working in the immigration policy and legislative advocacy area. It's been an interesting week, and I'm happy to be here to share sort of my thoughts on it.
Great. Thanks, Mike. To quickly go through, another differentiator of our service is our proprietary immigration management platform, Voyager, which we've created. This is really important for things like right now when you have issues pop up in immigration, for tracking, for extensive reporting. It includes dashboards for transparency, efficient workflows for cases, extensive, as I mentioned, immigration reporting before. You can report on any piece of information that is loaded into our platform for your national population. And then we provide a comprehensive knowledge center, which also includes blogs, access to detailed collateral materials for green cards, for visas, as well as our webinars, including today's. So to the agenda today, because I want to get to it very quickly here. Really, we're talking about a few things. Certainly, we'll get to consular processing and travel for folks later this year. But breaking news, really, in which I think everyone is really into the webinar for today, is the Presidential Proclamation that creates a $100,000 H-1B filing fee. We will review the timeline of that, the proclamation, what our general consensus is on how this will proceed forward. Um, right on the tail of that, I believe yesterday or perhaps Tuesday, there was an H-1B lottery proposal, a rule that was proposed. You don't even see it in the agenda today because it happened so quickly before our broadcast time today. So we'll be covering that as well. And then we'll proceed into in-person consular appointments, third country consular processing, proposed H-1B. Oh, there it is, the proposed H-1B rule. Excuse me. I saw it lit. We just changed the deck before we joined here. Rigorous screening on security review for visas, and then wait times and backlogs, excuse me, for visa processing abroad. Mike, do you want to take the lead on the $100,000 H-1B fee that was announced, I believe, on Friday last week, and what the timeline and our advice
Sure.
is around it?
Yeah. No, thanks, Matt. Yeah. So in putting this together, everyone, I think what we thought we'd try to do is sort of go through the chronology of what happened with respect to this $100,000 fee over the last few days. And I have to tell you, it's been an amazing last 6 or 7 days. I may be showing my generation here, but I feel compelled to borrow from the Grateful Dead. And what a long, strange week it's been in terms of employment-based immigration. Our area of the immigration law has been largely unaffected by the new administration. And until now, I think a lot of the focus has been on removal and asylum, but that changed with force on Friday. And if you thought you were blindsided by this, let me tell you, almost everyone was blindsided by this. I saw an article earlier this week that Jamie Dimon, the chair of JP Morgan, said that they were all caught off guard by this announcement on Friday. And in fact, I spoke with a friend who used to work on immigration policy in the White House in the prior administration, and it's her understanding that a lot of the agencies, CBP, USCIS, okay, I will speak more loudly, thank you, and the Department of State were also, to an extent, blindsided by the announcement. So on Friday afternoon, sort of middle of the afternoon, we got word that there was going to be a proclamation signing by the president relating to this fee. A couple of news outlets had reported it earlier. We were looking to see if there was truth to it. I actually got in touch with a friend of mine who actually writes for Bloomberg, and he verified that information was accurate. It's something that we had no preparation for, so a lot of us were just sitting and watching this Oval Office signing ceremony and learning about it for the first time. You go ahead, Matt. Go to the next slide. I think a couple of things I wanted to emphasize is that there weren't a lot of facts in the proclamation. There weren't a lot of facts in the discussion about the proclamation during the Oval Office ceremony. The facts that were discussed were inconsistent with some of the language of the proclamation. So, there were a few real hard facts to go with, and some of them were inconsistent. And frankly, because the consequences were so great for many people, a lot of us spent many hours on Friday night into Saturday morning really working with clients and trying to share with them that returning before the effective date, which you see was 12:01 a.m. on Sunday, was it probably a good thing? So just briefly, the presidential proclamation, said that H-1B petitions will not be approved and H-1B immigrants will not be admitted unless this $100,000 fee was paid. By way of background, it's a fee. It was attempted to sort of present this in the guise of an entry ban, but it really is a $100,000 fee that's being added to new H-1B petitions. So the proclamation mentioned the fact that there would be a national interest exemption from the fee, and didn't really provide a lot more information really that we could use to advise clients about the impact of this 1,000 fee on their foreign national employees, both in the United States and abroad. So just to highlight, there was one part of this proclamation that hasn't gotten a lot of attention so far for obvious reasons. But I think it's one part of the proclamation that might have the most enduring significance. And that is that requirement that the Labor Department initiate rulemaking to prioritize high-skilled non-immigrants, essentially in the H-1B category. Now, just by way of background, history is that the first Trump administration did try to do this. They tried to do a regulation to change wages, and it would significantly increase all four of those wage levels that many of you may be familiar with that help determine what the prevailing wage is and what the required wage is for non-immigrant visa petitions and labor certificate. Significantly adding a barrier to entry-level workers to participate in non-immigrant visas or green card sponsorship. So that's something that the agencies actually are going to be doing that, if it's done properly, could in fact happen, as opposed to the proclamation. So we're Friday morning or Friday night into Saturday morning, working with clients and helping H-1B workers understand whether it made sense for them to try to find a way to get on a plane to get back before midnight. At the same time, the immigration community was working really hard to try to get information from the administration about a lot of issues that we were very concerned about. If we had clients who were abroad, who just happened to be abroad on Friday when this announcement was made, are they going to be allowed to board planes? Are they going to be admitted as per their existing visas? If someone is deemed to be subject to the fee, how are they going to pay it? What's the process? Who gets the fee? It's $100,000. We need to be pretty clear about where that money's going before we were going to issue any payment. And then there was this discussion of this national interest exemption, but there was no discussion about what the standards are, how it's requested, or how it's going to be adjudicated. So there's just lots of questions circulating within the immigration bar community. At the same time, we were trying to advise clients to look for options and venues and flights to get back to the United States before midnight. At the same time, go ahead.
I just want to point out there that the executive order required a payment of this fee before a certain time to get back in, yet they didn't provide a means of actually making the payment anywhere. So you can just in that situation or structure alone, you can see the kind of absurdity or kind of backwards way that this was rolled out without any notice to even the departments that control or are required to enforce these rules or this executive order. So go ahead, Mike.
Yeah, no, I agree with you. I think that actually kind of lends credibility to a comment made by my former colleague who used to work in the White House, that the agencies were blindsided by this too. There was actually, as I understand it, an interagency call or meeting that happened sometime on Saturday where they could all be in alignment about how they were going to implement this presidential proclamation, which suggests if they were doing that hours after it was announced and hours before it took effect, there really wasn't much advance notice from their perspective. But the one point I want to emphasize, and then we'll move on, is that, again, the third layer of this on Saturday morning was that litigators were contacting some of us, and they were telling us that they're drafting litigation to stop this from happening. Can you help us find plaintiffs? So there are three layers to this. That one, I think, was one that was operating primarily within the legal community. But I want you guys to all know that litigation was contemplated almost immediately from the announcement of this proclamation. So let's move on. Yeah. So again, I think as the agencies and as the administration were realizing, how the heck are we going to implement this thing? There started to be, I think, a consensus that there had to be some guardrails, right? So they had to have some guardrails. And there were news reports that were circulating during the day that it wasn't going to be imposed on H-1B workers abroad, and that it was only going to apply to new applicants, not those with existing visas or those applying for renewals of existing visas. And then there was also this sort of unusual, hard to really understand how it would work comment that it would be effective on September 21st, but wouldn't be implemented until next year's lottery cycle, which frankly, I can't connect those dots. Maybe someone smarter on this call can, but it was just harder to figure out how they were going to do that credibly. So there was lots of information still circulating, lots of uncertainty. Go ahead.
Yeah, I think the play there from the administrative agencies, Mike, is that they need to go through the proper, the Administrative Procedures Act requires a rulemaking for a lot of these things. In the past, when new fees have been introduced, it's gone through an entire rulemaking comment process. Right. So I think they're just buying themselves time, saying it won't be implemented until the fiscal year 2027, which is October 2026, by the way, for anyone. That means that it may be applicable for or sorry, it's fiscal year 2027's lottery. Yeah, so that's next year in March, correct, Mike? Or April. This
Yeah,
may
yeah. No,
apply.
fiscal year 2027 starts on October 1st, 2026. So the
Yeah,
lottery for fiscal year 2027 will happen in March of next year.
correct. So my interpretation there is that this is just buying time to allow rulemaking process to potentially be underway to at least avoid the Administrative Procedure Act challenges that would pretty easily enjoin it from immediately taking effect or defeat it in the first place. So
That's certainly a scenario. I think, Matt, I appreciate your giving the administration and the agencies that much credit, but I'm not sure that there is a really well-defined plan yet, or if there is, it hasn't been announced. I mean, I've talked to others. Again, another individual who was in the immigration, in USCIS in the prior administration, and there's a sense, and I'm just saying this is one perspective that. This was really done for political reasons, not for actual legal intent. That this is something that would appease the base of the Trump voters. That this is something that they've been clamoring for, this H-1B visa, which they've been very critical of for very many years. And there really never was any real expectation that this would pass legal muster. But that's just one theory. Well,
yeah,
that's
that's
actually
fair.
that's actually yeah. But I'm not a conspiracy theorist, but that certainly had some traction with me. So on Saturday afternoon, a lot of us are sitting at our computer screens, and all of a sudden we saw a document that was forwarded from someone who forwarded it within the White House that indicated that this fee was not an annual fee. It's unlike what Secretary Lutnick said on just the day before. It's a one-time fee that applies only to the petition. It confirms that it's not going to be applied to individuals who already hold H-1B visas and are outside the country. And it also said it will apply to not, only to new visas, not renewal. And again, there's this sort of incomprehensible language that it's going to be effective, but it's not going to be effective until next year. So
Yeah, so
yeah.
I want to revisit that. So this means that H-1B change of employers, H-1B amendments, H-1B extensions, anybody that currently is in H-1B status would not be affected by this fee for any petition filed to extend, amend, or change employer. Mike, is that your reading as well?
Yeah, I think that's right. I think what we've already seen in tracking the experience of immigration lawyers over, well, the past 3 days, frankly, is all we have, is that individuals who've had actually had visa appointments based upon prior approvals have not been charged the fee. Applications that were approved after Monday and after, have been approved without regard to the fee. So again, the agencies seem to have been caught unprepared, and they haven't been implementing it. And the guidance is it's not going to be applicable at least until the cap filing season. I think, to match your earlier point, one maybe connection to that is they're not going to have procedures to accept the fee for weeks or
It's going to
months.
take, yeah, they're going to have to,
So,
all this stuff's going to have to happen
yeah.
administratively to be able to accept this in the first place if it ultimately is effective.
Yeah. So let's move on next. I think next slide. So culmination of that interagency meeting and culmination of, I think, some damage control, because I would suspect there were a lot of very senior folks at a lot of very senior business entities who were contacting the White House on this. There was announcements from the White House. There was announcements from USCIS. There were corresponding announcements from CBP, Customs and Border Protection, the State Department, all indicating basically the same thing, which is to say that the proclamation is not going to apply retroactively. It's only going to apply to petitions that have not been filed as of the effective date, and that it doesn't apply to H-1B workers who are petitions that were filed prior to the effective date, who have currently approved petitions, or are currently in possession of validly issued non-immigrant visas. So that was the big concern for a lot of folks that I spoke to on Friday and Saturdays. I've got a visa. I'm overseas. Am I going to be, am I allowed to board the plane? Am I going to be allowed to be admitted? Am I going to have to be turned around if I don't have $100,000 sitting in my back pocket? So this one tried to get some of those, the panic, for lack of a better word, actually it's the accurate word, calm down and let people know that it is going to be business as usual, at least with respect to those people who've already had an H-1B visa or been approved for status.
So that's a recap of last, first 48 hours there, I think. And forgive me, I know that there are some questions that we're not getting to today, but we have a lot to get through. So we will respond here afterwards to questions or follow up initially. Also, just FYI, if you have questions about this or would just like to reach out and talk to us directly for a consultation, please navigate to our website and fill out a contact us form, and we will reach out and schedule something with you as soon as possible. So, Mike, what we see going forward here for this $100,000 B fee, if we have some open issues, right? Applicability, as we mentioned before, does this apply to cap petitions only, cap exempt petitions, extensions of stay? I think, Mike, the consensus is right now from the immigration community in our discussions is that
Yep.
this
I
only
mean,
applies probably to the lottery going forward.
yeah.
However, it does say new H-1B visas, right? So a new H-1B visa could be these cap exempt organizations. If anybody's unfamiliar with what a cap exempt organization is, typically it's an organization that is a not-for-profit that is engaged in fundamental or basic research, or has a significant sort of collaboration with usually a university or an organization that is cap exempt in the first place. So you think
Right.
that these new H-1B visas filed by cap exempt organizations may perhaps be the reason for challenging or litigation?
Well, I think they are certainly most likely to be one of the groups of individuals who are most directly harmed by this. Certainly, there's one of the issues in the litigation. Two of the issues actually are standing to sue. Do we have aggrieved parties who are people who are injured by the agency action, and is the lawsuit ripe? By that, I mean, is there some action by the agency that is directly affecting their ability to have an H-1B or have an H-1B status? I think the ripeness issues can be overcome, but right now it's
Standing,
finding the
yeah.
right plaintiffs. So we're looking at actually that's ongoing right now. The lead team that's litigating this is circulating requests for individuals who are working for cap exempt organizations, do have petitions approved, or are in the process of filing petitions who are being prevented from doing so because of concerns about this fee.
Yeah. So just to recap there, you think standing is the issue here, the ability to be able to sue because you are injured. Typically in procedure and rulemaking with the government, you can't sue on a rule that's being made until it's implemented. So this is something that will be implemented in 2027, right, Mike, for at least for-profit cap
We,
subject employers, right?
my crystal ball has not been working since Friday, so I'm not going to predict what's going to happen with this. We're really basing our comments to you all today, based upon the 3 days of actual experience and from hearing from other immigration lawyers and trying to share that shared experience with you all. In my actually, I would just say if you are at a cap exempt employer right now
Mhm.
and you are interested in connecting and participating in this litigation, please reach out to Matt or myself after this presentation today, and we'll put you in touch with the litigation team that's leading this effort.
Yeah. So outside of standing, of who this applies to, whether it's cap exempt organizations or cap subject organizations, only when they file future H-1B lottery petitions, there is the payment procedure, right? They have none of the agencies have established any way to actually make this payment, this $100,000 payment, or any function or website to go enforce this, or any team to be able to handle it in the first place.
Mhm. That's correct. Yeah.
And then, as Mike mentioned before, there is a national interest exemption here that is interesting, where essentially it seems by the stroke of the president or maybe the DHS secretary or USCIS secretary that if you lobby them, you could potentially get a national interest exception. Except there's not a filing procedure for that right now, right, Mike?
Right.
How
No,
would people go about seeking that?
the only thing that, the only reference point we have is that presidential proclamation, which probably can't be too reliable at this point, can't be deemed too reliable, which talked about the national interest exemption applying to individuals, companies, or industries. So that's really as amorphous as a description of applicability as you can think of. So I guess the one thing I want to highlight here, and Matt mentioned it earlier, is that throughout my entire career, at least, there have only been two ways that USCIS has ever been able to increase its filing fees. One is through statute, right? So Congress passes a bill saying that fees are going to be increased in certain areas, like what happened with the what quote unquote big beautiful bill a few months ago, where fees were implemented for things like asylum and EADs. So Congress can change fees clearly. And then there's a procedure, there's a mandatory regulatory procedure that the government has to go through to implement fee changes. They just did it a couple of years ago. Many of you probably still remember that. That was the first fee increase in over 6 years because it's a fundamentally difficult bureaucratic process to do the review and do the statistical analysis to justify the fee increase. So it's something that can't be done at the stroke of a presidential proclamation. And I think those are this is the main area, one main area of vulnerability of this fee is that it's an illegal filing fee. It's not an entry ban. It's an illegal filing fee. And I think that's something that we have to stop talking about it as an entry ban.
Yeah, I agree. Uh, let's see here. So I would confirm Mike's statements. I've only ever seen fee increases done via rulemaking process, which directly violates the Administrative Procedures Act. If they don't go through it and do it that way, there has to be comment. There has to be notice to businesses. For everyone that's on the call that doesn't realize this, is USCIS is self-funded. That's why these fees are so important, as they fund themselves in terms of their operations, whereas the Department of State, Department of Labor, their budgets are often approved by Congress and have to receive increases as part of the budget making process. Mike, anything to kind of close out on the H-1B fee? My personal opinion here is that we'll probably never see this implemented going forward, or at worst, potentially try to be implemented for the lottery next year in 2026.
Yeah. I would agree. I've actually heard from someone who was a lawyer inside the administration for ICE. I've another person who worked in senior levels for USCIS. They are incredulous that anybody in the general counsel's office of any of the affected agencies had a chance to review this and authorize it. I think this happened outside of the legal departments of the agencies because there's no way they would have actually given this a green light, given the serious legal obstacles to its implementation. So I agree with you. I think it's just a matter of time. I think the litigation's already been drafted by and large. We're just trying to get the right plaintiffs and the right numbers of plaintiffs to move to actually restrain implementation of this, because there are people right now who are waiting on the sidelines, waiting to file their H-1B petitions because they're afraid that they're going to get petitions rejected for lack of the $100,000 fee, extortionate fee.
So I think the advice that I would give here is to do nothing right now when it comes to your immigration programs, your recruiting. You're looking forward to the H-1B lottery next year, because there's so much uncertainty as to whether this will ever take effect, that potentially I don't think moving quickly here is actually the name of the game. I think here taking some time to see how this plays out with litigation over the next few months, which will certainly provide more information than we have right now. Mike, anything on your side? Close that up.
Let's move on. We're halfway through our hour, so let's keep going.
So they proposed a new H-1B rule this past week, which was published by the formal rulemaking process that the Administrative Procedure Act requires. Is that right, Mike?
Yeah. So while we were all sort of still reeling from our hectic weekend, we found out early on Monday morning that, or actually maybe it might have been Tuesday morning at this point, that USCIS had finally gotten around to publishing in the Federal Register that proposed rule. Actually, we discussed this, I think, a webinar or two ago, that would significantly change the way the H-1B registration process is conducted. So that was published in the Federal Register, and that's the way significant regulatory changes with the agency should happen. They don't happen by proclamation; they happen by notice and comment in the Federal Register. So this is something we talked about before. The weighted selection process for registrants and petitioners seeking to file cap subject H-1B petitions was the rule. It was published yesterday formally, but we got the announcement on Tuesday. And as we predicted a couple of months ago, the proposed selection scenario is based upon job level, prevailing wage job level. So there are 4 levels, and essentially, yeah, go ahead.
Do we just want to back up there? So for anybody that's unfamiliar with H-1Bs, every time you file an H-1B with the USCIS, before you do that, you have to submit what's known as a labor condition application, or an LCA, with the Department of Labor. In that LCA, your immigration attorney, or whoever's representing you, could be an internal resource for a business filing this stuff, has to classify the job that the individual will eventually be sponsored for as an employee into a job bucket called a SOC or SOC code. And within each SOC code, there are 4 different wage levels that your immigration attorney can choose based off of what the actual wage is and comparison to the seniority of the sponsored H-1B position. So, Mike, you're saying that this H-1B lottery rule is tying potential rate of selection or chance of selection to the wage levels inside of these SOC codes that
Yes,
attorneys are choosing for clients.
no, exactly. I think what the administration did was they learned from their prior experience in the first Trump administration. They tried to do something similar to this, which was blocked for a lot of reasons by litigation, but it would have actually ranked H-1B petitions by salary level and started issuing H-1B registration allocations based upon highest salary to lowest salary. That was pretty clearly illegal. So this time around, they've gotten a little bit more of a sophisticated approach, which is we're not going to rank them per se by occupation, but we're going to weight the lottery process so that someone who's at a level 4 for their job and area of intended employment has 4 times the opportunity, 4 entries into the selection process, more than some, and then level 3 would have 3, level 2 would have 2, level 1 would have 1. So if you do the math really simply, if you have 4 jobs, 4, 3, 2, 1, the level 1 job has a 1 in 10 chance of being selected. So not really very good. So that's what this is trying to accomplish. And if we want to go ahead to the next slide.
Sure.
So this was the espoused rationale in the regulation. It's really, we want to favor the selection of highly skilled and highly paid non-immigrants while protecting the wages and working conditions of U.S. worker. So they went into great deal great deal of detail in the regulation about how the current system is really geared towards level 1 and level 2 H-1B workers, and highlighting the fact that levels 3 and 4 have been historically underrepresented over the last several years. So there's a lot of data that they use to buttress the argument that we need to re-engineer the H-1B registration process. And it would really, it's requiring, there's going to be some changes to the forms. In fact, there are samples of the new registration forms that are available for comment as well, that will highlight the OAS wage level that is in place for again, the job and the area of employment. And that will be the basis on which the number of registrations will be determined for that particular applicant. Keep in mind, of course, that we're doing this beneficiary-centric registration process again. So that's stage 1, doing the beneficiary-centric part of the selection process, and then 2, allocating essentially lottery tickets based upon the wage level.
So to the beneficiary-centric procedure, which not everyone might be aware of, has changed, I believe, last year or the year before, correct, Mike? That it used to be the number of H-1B lottery submissions you submit for one individual. You could have 10 companies sponsor for one individual and potentially 10 chances of being selected in the lottery. They changed it to if 10 companies sponsor one individual, the individual only is selected in the lottery, and then they have the ability to choose which company they want their sponsorship to be supported by of the 10 companies that may have applied for them.
No, exactly right. And I think that part of the problem in the prior years was that was not impermissible. And in fact, there were some very energetic and hardworking H-1B employees who actually had over 30 registrations submitted them before the rule was changed. So it was a pretty incredible process, and it did game the system, quite frankly. So this was designed to do
that. So to just to kind of summarize here really quickly, depending on the wage level that the LCA will be filed at, that will determine the number of entries that someone gets into the lottery, right? Mike, do you think this is I mean, so what do you think are the ultimate effects of this are, in your opinion, after digesting the rule?
Well, I mean, I think if the rule takes effect, and that's a huge if this rule takes effect, it will pretty much create a very hard barrier for entry-level H-1B professionals. So one of the main sources of innovation and growth in many industries is the foreign students that come out of our colleges and universities around the country. They're not, if there's not a viable pathway for many of them to have a career path in the United States, not only are they not going to stay after graduation, they may not even come to the United
They're not
States.
going to come. Yeah.
Yeah. So I think the ripple effect of this weighted registration process may take a few years to play out, but it will have I think, a pretty significant impact on how and where employers do business. And we can talk about that in a minute, but it'll also impact colleges and universities, because I'm sure, as many of you know, foreign
Significantly.
students pay full tuition, unlike a lot of U.S. citizens who are attending college right now. So it would be a significant fiscal impact on the hundreds of colleges, thousands of colleges of universities around the country that accept foreign students.
Do you want to talk about the specific rules here, Mike, with the work in
Yeah,
multiple locations
I'll go through
in the
it.
proposed rules?
Yeah, there's a good deal of emphasis on individuals or employers trying to, quote, unfairly increase the odds of selection. So if there are multiple petitions filed for the same individual, which is still permissible in the current rules, the individual would be placed in the lowest level of the multiple petition. So if one was level 4 and one was level 1, then that person would get a level 1 designation for purposes of their entry into the lottery. There is also great concern about shifting workers around to try to take advantage of lower wage scales in parts of the country and different kinds of occupations. So if you start out as a level 4, and just hypothetically say you're a level 4 engineer in Boise, Idaho, and then after that you move to a different occupation in Chicago or New York City or Los Angeles, where you would otherwise be maybe a level 2, the agency is going to take a hard look at that. And there could be a very strong presumption that you would have to rebut that you as the petitioner did not attempt to unfairly increase the odds of selection. Penalty: denial of a petition or revocation of an approved petition if they see that's the case. So they've tried to be very clear that they're going to be looking at, I think they call it program integrity in the regulation.
Mm-hmm. Yeah, so the overall scheme here is try to file the highest wage level possible to give your individual and your organization the best chance of selection, but you'll probably be locked into that wage level after selection and approval of the H-1B, otherwise be accused of unfairly increasing odds of selection and potentially committing fraud in the H-1B lottery. Is that, Mike? I think that would probably
absolutely.
come as part of the request for evidence in that next filed petition.
Right. I think it's something that they acknowledge in the regulation that there may be legitimate business reasons for doing that. But I do think that there will be a presumption against any petitioner in that scenario to provide detailed information as to why that was necessary and why it was not an attempt to gimmick the system. So I think I would say be very careful if this rule takes effect in that scenario that I described earlier about Boise and Chicago or New York.
Yeah, and I'd like to highlight there is significant uncertainty as whether this rule will ever take effect. So let's take a look at, what happens next now that this rule's been published for an open comment period, Mike.
Yeah, so procedurally, the regulation provides for a 30-day notice and comment period. And already there are numerous organizations in the business sector and in the legal sector working on developing their comments. I'm on a comment team that's drafting the American Immigration Lawyers Association comment to this regulation, and we're already outlining our proposed response. I think the answer is there's going to be a lot of input. And if you're interested, your organization is interested in participating in the comment period, please feel free to contact me. I've worked on numerous regulatory proposal comments, and I can help with any procedural guidelines that you may want to talk about. So bottom line, the statute, again, this Administrative Procedure Act, requires that USCIS must review each and every comment it receives and provide a substantive response in its final rule. So that's why those final rules are so lengthy, in that the agency is required by law to say that it reviewed the proposed comments and it has a response to them. Typically, final rules are effective 30 days or 60 days after they are published in the Federal Register. So, there's some, just sort of doing some reverse engineering of the time clock here. So as we said earlier, the registration period for fiscal year 2027 H-1B will start in early March, like it has in years past. And to accomplish that, you count backwards. really the final rule has to be published absolutely no later than towards the end of January. My own expectation is that the final rule will be published with a 30-day effective date. The fact that they used a 30-day comment period strongly suggests, because the standard for a major rule like this would be 60 days in practice, but the law only requires 30 days. The fact that they use 30 days suggests that they're going to try to push this through, if at all possible, for next year's registration cycle. I think that's really ambitious, frankly, given the time frame and how the agencies work in reviewing, and the multiple agencies that are involved in reviewing the comments before it's published in the Federal Register. But certainly it signals an intent to do so, similar to the F rule that was published even earlier. That also had a 30-day comment period. That's also something that looks like the agency is trying to push through pretty quickly. So the last thing I guess I want to discuss on this topic is, potential litigation that might postpone implementation. And again, there are members of the immigration bar who are looking really hard at this as to whether or not this is permitted under the statute. And I know we're running short on time, so I'm not going to spend a lot of time on this, but the statute, the H-1B statute, requires that when more application registrations are submitted than there are visas available, and as you all know, there's 85,000 visas available. When more than 85,000 are submitted, there is supposed to be a, quote, random selection process, end quote. That's the statutory language. So, question, how does a weighted selection process, which clearly favors one group of applicants over another, meet the statutory requirement of a totally random selection process? I haven't heard too much about the litigation proposals on this yet, but I would very strongly suggest that's going to be a core argument in challenging this proposed rule.
And Mike, I think comment pulling back, to 10,000 feet here, was there not a case with the Supreme Court, I believe last year or potentially the year before, where they further constricted a agency's right to depart from publishing regulations that significantly depart or do not exactly match what the statute says?
Yes.
In a separate case, a completely unrelated immigration case, and forgive me, I can't think of the case off the top of my head.
The lead case in this area, there are several now, was Loper Bright. And Loper Bright really instructed the Supreme Court instructed the judiciary that the prior deference that courts have given to agencies' interpretations of law no longer need to be given, that the courts are entitled to make their own determination as to whether the agency interpretation in fact comports with a law. So when you've got something, at least in my humble opinion, that's as bright line as this, random selection process versus weighted selection process, I think there's a real argument that Loper Bright suggests that the courts could come in and say this is unconstitutional. Oh yeah, the Chevron case was predating that. Chevron deference, I saw the question. Yeah. Chevron deference has been supplanted by the Loper Bright. Yeah.
So in a way, a conservative decision may be the reason that this, the conservative judiciary's decision may be the reason that this rule ultimately fails, because it departs too much from the stated statute. Interesting. Mike, I know there's a couple other things that are going on right now, so we'll move to increased dual scrutiny on H-1B employers. This is important. I know we'll try some of the travel stuff here, or we can maybe cover that in a subsequent webinar later this month.
I'd like to, Matt, I'd like to call an audible here. We've got a lot of questions in the chat. Maybe we do this next slide and we try to cover some of the questions in the chat. We're going to have to do a full session on travel guidance probably in next month or the next 2 months. So I think given the fact that, so many of the folks on the call right now came to talk about the H-1Bs, let's see if we can get through some of those. I think there are 20 questions in the chat right now, maybe 21 now.
So let's cover the increased compliance directive here, and then from there we can break off. And Mike, I don't have access. I'm sharing my screen. I can't see them. If you want to just read off the questions thereafter, you and I can tag team them. I
totally understand. So while we were all sort of running around trying to put out all the fires on Friday with respect to the $100,000 fee, something that kind of slipped under the radar was a Department of Labor announcement of the start of what they're calling Project Firewall, which it has an obvious connotation when you understand what it's all about. suggesting, actually stating that the agency is going to be prioritizing investigations of employers for H-1B compliance. So, the proclamation doesn't provide a lot of details into what that means. In fact, the DOL has always had investigative responsibility. It's just not been, I think, enforced as widely or as broadly or as aggressively as we're likely to see in Project Firewall. The focus is really to probably aggressively pursue tips that are provided by H-1B workers or U.S. citizens. A goal, again, protect the rights of American workers. It's a common theme throughout much of what's happening in the H-1B space, because there is a perception that the H-1B program does not supplement the U.S. worker. It's replacing. Yeah. So penalties are pretty significant. Obviously the monetary penalties are not not insignificant, but the real issue is the agency has the ability to bar companies from participating in the H-1B program. So that would be a real death knell to your ability to attract and retain talent.
And that would be a bar on an organization's cap subject for filing LCAs, correct? To the underlying premise of the H-1B that's submitted to the USCIS for prevailing wage purposes.
Right. So you absolutely could not go forward. So, and it's not just the DOL. There are the Justice Departments involved. There are other agencies involved. So this is going to be a significant uptick in investigation of H-1B employers. So one takeaway here is that monitoring your public access files, making sure that the representations made to USCIS and the DOL are actually what is happening on the ground. So if the H-1B worker was, the H-1B petition was submitted for a worker as a software engineer, that they're performing that rather than something completely different. So I think there's an area where employers can sort of try to get ahead of the implementation of Project Firewall by looking at their records and maybe doing some compliance auditing of their H-1B program.
Yeah, and to be clear, the Department of Labor has always had the ability, Wage and Hour Division, I believe, to investigate public access files, as the USCIS also has an enforcement agency, the FDNS, the Fraud Detection and National Security Unit, which also investigates compliance with the H-1B program. This is an additional directive above those compliance functions already, Mike, and we probably would see, what does this mean to employers? You're likely going to see more emails or site visits to check on the H-1B compliance. Is that correct?
Oh yeah, I think, and also it's not just wage and hour. They've included the DOJ's anti-discrimination wing. IER is going to be involved. So they're going to be looking really at instances where U.S. workers are being disadvantaged by the H-1B program. So that's really the driving force behind this Project Firewall is looking at employers who may have given a preference over to H-1B workers in the process. So,
review your site visit policies. Obviously, public access files, just to highlight, we manage those for our clients. They are compliant because we review them and audit them regularly. If you don't have a provider that's doing that, certainly in an area to investigate right now. Mike, anything on increased DOL scrutiny here before we move to?
That's the last thing. Just in total candor, there hasn't been a lot of focus on that yet, and I think we'll learn more when we start hearing about investigations. And one thing I will say for primarily IER, Immigrant Employee Rights Division of the Department of Justice, as well as to a lesser extent Wage and Hour, if they're finding employers or they're finding employers guilty of discrimination or not paying required wages, they will publish it. They are very press release happy. So we'll find out what enforcement is probably in the weeks and months ahead.
I would, in this process, something that sticks out to me before we get to questions here is in most of the, my 15 years of practicing, I've seen most audits done by ICE or the Department of Labor as a result of an employee complaint. Is that right, Mike? So that really provides it looks like here, employee complaint could be the reason why you're getting investigated by the Department of Labor, IER, and the Department of Justice. So I would caution folks, as you're doing RIFs and or other things that are happening that may affect U.S. citizens, a complaint from one of those individuals that you lay off or fire for cause could be the reason why you're investigated hereafter. And so I think something just to note and take into account. Okay, Mike, do you want to let's tackle questions for? I think we have about 7 minutes left.
We have a little over 5 minutes, and I will try to get through as many questions as we will try to get through as many questions as we can. The first caveat I'm going to have to say for all of our answers that we are 5 days, 6 days into some of the the rules around the proclamation. So we are going to give you our best answer as to what we think the rules are. These are not, we're not giving legal advice today. I think if you want to have a specific answer about a specific question, I think feel free to reach out to us and we can dig a little bit deeper. But I'm going to go from the oldest question to the newest and try to get through as many as we can. And then from there on, if we don't get to your question, we'll get back to you after the webinar. So question, will there be certain industries exempt from the 100K costs, such as teachers? We are an educational entity and teachers come over on H-1B visas, wondering if there will be exemptions.
So you may qualify as a CAPIT exempt petitioner in this case, right? We don't know if there's going to be industry exemptions at all. Mike, have you heard anything?
No, that goes back to the national interest exemption, which was mentioned but not defined in the proclamation. And there hasn't been any guidance from USCIS on how that's requested, what the rules are for obtaining it, or how it be implemented. So
I think what we've preached along with in the webinar, patience here, and I wouldn't move too quickly before we have more information around some of these things. Go ahead.
No. So second question, if someone has already applied for a petition in June 25 and is still waiting back to hear back from USCIS, will the fee affect them or is it for next year? My qualified answer is that the fee, based upon our adjudication experience of 4 days now, is that the USCIS is not applying fee to pending petitions.
I agree. And I think it is most likely that it only applies to next year's lottery, or which would be submitted for and filed in March or April 2026.
Next question is the fee due at the time of application or when it is picked? My kind of trite answer is, who knows? We haven't had any guidance on this so far. But I would say our expectation is that if we start seeing this, it will be for petitions and applications that are submitted on Monday or later that were submitted with the regular fee. And we may see an RFE that provides them with instructions on how to pay the $100,000 fee. Presumptively, who knows, through pay.gov. But the answer to that question is we're not sure yet. But I think
Go ahead. I think logically it makes sense there that with regard to the H-1B lottery, it would probably only apply to folks that are picked in the lottery and thereafter have to submit an H-1B petition.
Oh, that's 100%. Yeah, absolutely 100%. If you're, it's going to be on the petition, not the registration. Yeah. Mm-hmm. Okay, next question. I have an upcoming H-1B extension. Data filing will be after September 21. What I understand is fee is not on renewal. Is that correct? Yes, that's my understanding.
Correct.
Can I go to home country and come back with a new approved petition without paying the new fee of $100,000? I would say that's not an entirely clear answer. I'd say we'd have to look at that on the data, when you're arranging for your interview. If I were counseling you, I'd say, I believe that's correct. But I think I also want to be careful about that because the State Department hasn't been really clear about visa applications that are submitted after September 21st. So I think that one's a qualified yes.
Yeah, I think with the information we have right now, you probably will not be affected in traveling. But stay tuned for our next webinar next month or next week.
Yeah. What about CAP exempt cases, change of employer or transfer petitions? So I'll take that in reverse order. Sure. Change of employer and transfer petitions for individuals who are in the United States. So far, the guidance and the experience actually indicate, not suggest, that they are not subject to the fee. CAP exempt cases filed after September 21st, we still don't know because it's just too soon.
And these would be CAP. So this would be new CAP exempt H-1B submitted by CAP exempt employers or brand new H-1Bs for individuals that have never held H-1B in the past. That is the advantage of the CAP exemption, is that you do not have to go through the lottery, depending on the structure of your organization, to file these new visas. And to Mike's point, I agree that we have not heard or seen a rejection or started hearing of denials for cap-exempt organizations filing new H-1Bs yet.
Right. Okay, we got like 1 or 2 minutes left, so I'm going to try to knock off a couple of them really quickly. If the petition was approved, but I haven't gotten the visa stamp and I want to go now to get it, is that okay? I think we just covered that to an extent.
Yeah.
I think that should be okay, but I suggest caution right now because there's not 100% certainty. Is there any likelihood that a fee for renewals or transfer will be introduced later? No, I don't think so. Based upon the guidance that we've been receiving so far, it seems that it's a one-time fee for new petitions. You guys are delaying H-1B to get more information from the government authorities renewals. Okay, I'm sorry. Let me see if you guys delaying the upcoming H-1B extension renewals to get more information, clarification from the government and authorities, or the extension renewals will be filed as planned. I guess they're asking,
Yeah, should we my advice to our clients and how we're representing is it's business as usual right now. Continue to file stuff. The H-1B, you don't believe the H-1B fee via the clarification from the USCIS and other governmental agencies will apply to extensions, changes of employers, amendments, potentially only to new H-1B visas, folks that are filing that have never been in status before. I think that's my advice to
Yeah.
current clients. Mike, do you agree?
I mean, I think the only reason that this proclamation has not been enjoined in court is because of all the backpedaling that's happened by the agencies over the last few days. The lawsuit is ready to go. We're just there's an attempt to refine the plaintiff class, and I think when that when that lawsuit is filed, excuse me, I think there'll be a temporary restraining order that will prevent this from being applied in any sense. So,
So, Mike, want to go? Let's cover a few more here if we can, really quickly.
okay. Will this apply to stamping for existing H-1B holders traveling to India after renewal? Again, the guidance that we've received so far suggests that the fee will not be applied to renewals. Actually, that's a term that the State Department used in their guidance. But we're going to counsel everyone who's going abroad to really sit down and have a really thoughtful consultation about their situation before they travel, again, until the rules have become more black and white. Do you foresee any changes to the renewal process considering these changes? No, I don't. This is not a substantive change. This is, as I said before, this is an illegal filing fee that's being imposed by the administration in an attempt to deter H-1B sponsorship. If a company has applied for H-1B candidates and they were selected in the lottery system in April of 2025 and the visas are still pending, if approved, will they be subject to the $100,000 fee? From a USCIS side, I think the answer is pretty clearly no, that they will not be subject to the fee. Again, if they were to go outside and apply for the visa, we believe that they won't be subject to the fee, but that's something that hopefully the DOS will confirm in the days ahead.
Mike, you want to scan anything you think is seems like I think we've covered. They don't think the fee will apply to existing applications right now. Anything else that diverts from that?
I think that a lot of these questions relate to similar themes, but we could go back. It's 1:02 right now. We can go back, I think, and look at them maybe after the webinar and
Sure.
and answer them individually.
Yeah, I guess I think we'll close up there. If again, if you have a more detailed question, we'll try to get to it after the webinar today via email. If you have additional concerns, feel free to schedule a consultation with us on our website. I think the overall theme here, Mike, in my mind, is really just patience. We don't know enough yet. We know that it probably won't apply to existing applications or this year's lottery applicants that were selected and already filed. It may apply next year. There may be litigation. So I think moving slowly here, which is something I don't advocate in many cases, is probably the best advice that we can give everyone.